Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve some time, please let me know, as I'll be keeping track of the time. Arguments are being recorded. Please keep your voices up. Remain behind the podium. Please don't use the names of children or minors or victims during your arguments. The judges have read your briefs. We're ready to proceed when you are. So if you would like to reserve time, now would be a good time to tell me.
Thank you, Your Honor. I would like to reserve 5 minutes for rebuttal.
Very well. Then you may proceed when you are ready.
Thank you. Good morning. May it please the court, esteemed counsel, Corinne Hoover Six on behalf of the appellant Loewe. We are here today on the issue of whether the trial court erred in applying the wrong analysis in a modification of spousal support proceeding. It's the post-decree proceeding years after a divorce was granted. My client, at the time of the divorce, was fully employed, earning approximately $200,000 a year. His wife in a long-term marriage had primarily been a stay-at-home spouse and mother, and was earning approximately $15,000 at the time. At the time of the divorce, wife was granted a pretty substantial spousal support obligation of approximately, I believe, $8,000 a month. Fast forward years later, my client filed to modify spousal support based on 2 different changes of circumstances. The first was done at the beginning of the COVID-19 pandemic. My client, Mr. Loewe, was in the horse racing industry, and like most industries in the entertainment sector, was shut down completely, unlikely to return, or the future was unknown. So his first modification was based on the fact that he had been furloughed from his job. Months thereafter, he filed a subsequent request for modification based on giving a retirement notice. Retirement notice was given at age 63. The matter finally came to a hearing in front of the trial court when my client was 64 years old. At the time of that trial, he had retired and he was earning $0 as compared to his prior earnings of over $200,000 after having spent 42 years in the same industry. The trial court found that Mr. Loewe was voluntarily underemployed and therefore imputed his pre-retirement income of approximately $200,000 to him for the purposes of calculating and determining spousal support. The major issue here is the trial court found my client had retired early. However, this court, as far as I have been able to find, has not defined retirement age.
So you want us to make a bright line rule about what age you can retire?
I don't know that that's it. I think other districts have held it's a case-by-case basis. The Ohio Supreme Court, in a non-domestic relations proceeding case cited within my brief, indicated all the way back in 1997 that retirement age is no longer a certain age. And they held that in 1987 that retirement is commonplace even when people are 50 years old. And so I think that this case really kind of sets the stage for what is early retirement, what is justifiable retirement. Is it solely a case-by-case basis? The trial court didn't seem to opine on that either. They just said early retirement. I'm assuming that the trial court said 65 essentially was the age of retirement, although I don't know that and it's not said. So my client's position is he retired when he was eligible to do so after having spent 42 years in the industry, that therefore his decrease of income was involuntary based on a standard retirement age, and therefore his spousal support should have been modified based on that. The trial court, however, found that he was involuntarily underemployed. This court has found that retirement would justify a modification based on change of circumstance, but has said that that's a may. Other districts, including the 2nd District, has found that a retirement is a definitive change of circumstances warranting that modification. Our position is that the standard for the in order to hold my client responsible for pre-retirement income for the purposes of spousal support, there would have to have been evidence that he retired for the purpose of defeating the spousal support obligation, which is the applicable case law. The evidence in front of the court, as far as the record, does not support that. The evidence supports that my client at the time he gave his notice was eligible to draw on his 401k after having spent 42 years in that industry, although he chose not to do so at the time. The evidence also supported that he was able to take reduced Social Security benefits at that time based on being age 63, also chose not to do so. However, the trial court's analysis that he retired for the purposes of defeating spousal support, I do not believe is supported by the record. Although he was paying approximately $8,000 a year of spousal support, he was earning over $200,000. So I think it's an illogical position that the retirement was based on the purpose of defeating spousal support to his former spouse when he himself was going without over $100,000 of income based on this decision. Instead, our position of it is it was economically sound for my client to retire when he did. This court's prior decision, which is cited substantially in both briefs, is the Koch decision from 2004, which examined the issue of early retirement, in that case for an air traffic controller. In that case, the trial court said that essentially that person wanted to stop working, and that was his justification for retiring, and so therefore they were going to impute the pre-retirement income to him. This court overturned that decision, and instead found that just because he wanted to stop working, that wasn't enough to find that he was involuntarily underemployed and to impute that pre-retirement income. But they established that standard of let's look to see if this was economically sound to do so. The reason that my client believed it was economically sound for him to do so is his industry had changed substantially after COVID. The testimony is substantial as far as the travel that was included, his personal reasons for living 400 miles away from his wife because of his employment location, but more so the fact that when he was called back to work after a furlough, many employees that worked under him were not likewise called back. So his job duties increased substantially. He did have some health issues, although he did testify his health was generally good, but had some chronic back issues and things of that nature. But he determined it was economically sound for him to retire at that time because of the longevity in the industry, his frugal lifestyle. He testified, for example, in a used 2017 car. He wasn't living a lavish lifestyle and retiring on that basis, but was retiring because it was economically sound to do so for him in light of reaching retirement age, eligible for his 401k and Social Security, and in regards to the changing industry after being in the senior citizen age bracket. Our second major argument as far as why the trial court erred is this issue of wife's income that was not included for the purposes of spousal support. At the time of the divorce, wife received an interest in a family business. The decree is very clear that that was allocated to wife, free and clear of any claim from husband. It does not indicate that it is separate property, nor does the decree indicate it's marital property, just that it was allocated to her. However, if you look at 3105.171, which is the property division statute, that property division statute clearly defines inherited property as separate property. So our argument, of course, is that wife received that business interest with no claim to husband based on the fact that it was her separate property. For whatever reason, at the time of the original divorce, it was not included, apparently, from my review of the record, in the spousal support calculation. I can't say for certain, I certainly wasn't there, but when I picked up the file and looked, there was nothing indicating that it was included. There was no justification for why it was not included. Our position, however, is regardless of whether it was included or was not at the time of the divorce, that any modification proceeding is subject to the spousal support statute of 3105.18, and that statute specifically indicates that in determining the amount of spousal support, income from all sources must be considered. In fact, the statute is the court shall consider, not discretionary must. And that includes income from all sources, including income derived or dispersed of in the property division settlement. Wife, in this case, had substantial income from that family business.
Did someone raise that at the trial level? Because it was the husband's motion for modification.
Yes.
Did the wife make a modification order too?
No. Not that I can recall.
Although
they did, the court ultimately ended up modifying it upwards. But I believe that was too spontaneous.
And then did was that raised as part of the modification, not just retirement, but also?
Yes.
Okay.
Yes, and there was testimony about what that was. The original divorce record has no indication of what amount she was receiving whatsoever, just that she was allocated this business. The modification proceeding included testimony on what amount she received. It was about $65,000 a year. So when you take wife's, she has income from multiple sources. If you consider her income from exclusive of that $65,000, certainly you look at that, there'd be a gross disparity of income between the parties. But if you include that income, wife on her own is making over $100,000 a year, which then certainly adjusts the disparity quite dramatically. If husband is fully employed at $200,000 and wife's making $100,000, certainly there's $100,000 of disparity still. But if husband's retired and making zero and wife's making $100,000, if the court were to look at that income, I think that's a substantial factor under the spousal support factors. So it is our position here that the trial court erred on both bases. Yes, thank you. I will reserve the rest.
I apologize, I didn't really want to interrupt you in responding to your colleague's question.
Thank you, Your Honor. I certainly need to interrupt him when done.
Good morning, may it please the court. I'm John Donor. I represent the appellee, Denise Loewe. It bears going through a couple of the facts that are before the court in this case. This is a 31-year marriage. It's a long-term marriage by any standard. 28 months into the spousal support obligation, the husband files a motion to reduce or modify, not reduce, but to modify his spousal support obligation. He did that when he was furloughed. The evidence at trial was that he had communicated through counsel that he had no income during that period. And as it turns out, at the trial, he was receiving unemployment compensation during that period. And when he was making representations that he had no income, he was actually had the knowledge that he had been called back at $180,000 plus bonus, which is just $20,000 a year less than what he had been making up until April of 2020. He did not pay his support from April until the fall of 2020. He made a unilateral decision that he was unemployed or underemployed or however he wanted to frame it at the time, and he did not pay, and it took intervention of the court at a pretrial hearing to get him to pay that amount that was due. Right about that time, he was notified by his employer, October 1st, 2020, you're going back to $200,000 a year base plus your bonus package, which is about $49,000 a year. That same day, upon receipt of that notice from his employer, he submits his resignation effective December of 2020. In January, after he left that employment, he filed his motion, second motion, to modify his spousal support obligation. A couple of facts counsel said that were incorrect. He was making about $50,000 a year, $49,000 in his bonus rate prior to the hearing for 2019. And that was paid the first quarter of 2020, and he split that with wife as he was obligated to do. She was making $12,000 a year. She's a bookkeeper for a company that pays her $1,000 a month. That's what she does. Her health is poor. She had and has a brain tumor that she receives treatment for, and she has testimony about her health condition on the record during this proceeding. When people retire, they retire with a plan. On this side of the bench, I can tell you it's a 401k or it's some type of IRA or it is something that we are entitled to do as sole practitioners or in small firms. That side of the bench, you have a state retirement plan that is paying you. When you retire, you always consider, what am I going to live on? Mark Loewe said in the trial, I have no income. I have no income. He learned between the first and second motion that if he has income, it weakens his argument. He quits his job, he leaves that and maintains he has no income. As counsel accurately stated, he did not draw from the hundreds of thousands of dollars he had in his 401k. He did not take Social Security. The evidence is he did go to live with his wife, who he married right after the divorce, so they had been married, and she's always lived in Goshen, New York, and that's where he moved to. In fact, when he was married to my client, they lived in Goshen for a while. It was not something that was a surprise that his wife had to move. That's what compelled him to move. It wasn't. So he has no income, and he doesn't do anything to gain income. We all retire. We have income. We have a plan for that income. When he filed during the pandemic, he claimed that was it. The racing industry, he was the head of two trotting trotters, one in Pittsburgh and one in Youngstown. Prior to that, he was in Youngstown and Dayton and managed those two tracks. But he said he wanted this reduced because that industry was not going to recover. I think that was in his motion. It was not going to recover. It recovered immediately. In fact, like other things in the pandemic, it was a surprise that industry did well, and he was returned within months to his prior salary. He has planned for his retirement. If he didn't plan for his retirement, he wouldn't have a sizable retirement sitting there. It's the 401k that he had established, but he didn't access it. Why wouldn't he access it? It would be a stream of income to him that the court could consider when considering spousal support, but he's not accessing it. Social Security can be considered as a stream of income if he's accessing it. At his level, he would max out on Social Security. That would be part of what the court would consider. On the second issue, I'm sorry, let me just, one more thing on that. The term that the law provides, the courts have provided in their analysis, cited by both parties, was his decision to retire economically sound? How could it possibly be economically sound when he went from $250,000 a year to zero? What is the economic soundness of that? He could say, I did it because I had this to replace it, or he didn't have any argument for why he did it. The retirement age issue is a red herring. That isn't the standard. People can retire. Both parties cited different occupations where you retire at different times. No, the analysis is, did he do it to avoid his spousal support obligation? There is no other reason he did it. There's nothing in the record. There are no facts that say, this is why I didn't access my retirement. This is why I didn't access Social Security. These are the reasons that this is economically sound, and there isn't one except getting out of spousal support. He wanted to do it when he thought the pandemic stopped it, and he wanted to do it. When that didn't work, he filed. The other point is on the family business, there is an agreement. The divorce was by agreement. It was a separation agreement. The parties agreed that that would be considered her separate in its entirety. It isn't $60,000 each year. I think it averages about 40, except it is a swinging door. If, as my client testified at the trial, there are 3 funeral homes, I think, that comprise what the family owns, and she has a small stake in that. And they had a crematorium, and the crematorium, ironically, burned down. Now there's a cash call. Now, at the time of trial, we did not know, and I won't go further than that, but she testified that there will be a cash call because all the shareholders now have to contribute to anything necessary to rebuild that. That is part of that, and that was testified to. At the divorce hearing, at the divorce time, in the separation agreement, it's specifically mentioned that that she has this, she's going to keep it. It was mentioned in the temporary orders prior to that. And husband is now trying to pull that in. If the court allows that, this is what it does. If people agree that that will be separate, not considered for spousal support purposes, we're not considering it for spousal support in their agreement. A month, 2 months after the divorce, the payor is going to turn around, file a motion, modify it, include it, say it wasn't included. It nullifies the agreement reached by the parties. This court has often said that the agreement of the parties in the divorce is their agreement and they're bound by it. It is a different standard when they have a separation agreement than if they would have had a bench trial and the judge would have made the decision.
Isn't this distinct though than the agreement when you're talking about income that you have to claim on your taxes, income? If you have an agreement that a business is going to go to one spouse or the other, or a certain lump of money is for that spouse during the agreement, isn't that distinguishable from income that you use to calculate spousal support?
Yes and no. It was in existence and part of the consideration at the time they entered into the agreement, and it was not used. And now, it's, to open that up, I think would be unfair and would go against the agreement that they had originally reached at the time of the trial. But consider this also. Going the whole way back to the Collette case in 2000, this court has given its imprimatur to an equalization of income. My client would make $40,000 or $50,000 if they included that as her income from this business, less expenses. So there's nothing on the record of what the expenses, but she has expenses that may be associated with that. But let's say it's $50,000 and she makes $12,000. That's $62,000, and he is making $250,000. Spousal support wasn't $8,000 a month; it was $5,500 a month. That's $66,000. So when you start adding those figures together, she's not at the halfway point. And this is all before the tax law changed. This is all taxable to her. So she is not at the halfway point of income. Even if it's considered, it's still going to, even if the court adds that and looks at that, it is still an item that would allow the same amount of spousal support that the court ultimately considered.
Well, if we take the agreement literally, he'd have to pay spousal support till his death or she remarries. So.
No. The death of either party.
Death of either party or.
Her remarriage. Or change in
So
circumstances.
there would never be an end if we followed the agreement strictly to spousal support. So we do have to take a law into account here.
There can be an end. There can be a number of things that will end a spousal support obligation, but typically, in cases where, this is the example I give to clients when they come in and this point comes up, is if there is, the only asset is social, or the only income for each party is Social Security, and one person is earned so little that they're going to get half of their spouses. And let's say he gets $3,500 or $3,000 a month in Social Security, and she gets $1,500 a month, half of his, you go to court on a modification of spousal support, he's going to pay her $750 to equalize that. Does that go on forever? You bet. 31 years of marriage. By any definition, going back to Cherry versus Cherry, Supreme Court case from 1984, that is a long-term marriage, and indefinite spousal support is permissible, and often exactly what is supposed to happen for those very reasons. We don't know when it's going to happen. Can he get relief by retirement? Sure, he can get relief by retirement. We'll take it down to zero? I don't think so. I think that what he has coming in as far as Social Security and with my client's health concerns, it's never going to get there.
Thank you,
That's
Council.
it, that's all I have.
Thank you, Council.
To address the points raised by Attorney Donor, to start, the indication that my client retired 28 months after the spousal application. At the time that they were divorced, both parties were pushing 60 already. My client is older by several years. However, the factors for a spousal support modification include age and include retirement benefits. The other important thing to note is that my client's substantial 401k, for which he was not drawing at the time that he retired, that had already been divided under the terms of the divorce. So this is not that my client has some huge asset that he's sitting on and hoarding and saying, well, I'm just not going to draw on this for the purposes of defeating spousal support. Wife had already been allocated half of that. So his remaining half and her remaining half were equal under the terms of the decree. So that's the other factor here that the court has to look at, is that in determining spousal support, all of the factors listed in 310518 include the relative assets and liabilities. And so wife, at the time of the trial, testified, yes, she got half of the 401k. She didn't know what it was. She didn't know what she still had. But I think that that's a huge factor in looking at this issue of the equalization of income, which again is not statutory whatsoever. It's a standard that the Summit County Domestic Relations Court has applied for a number of years, or at least for now, at least one judge is applying, the other to be determined. That is not a statutory consideration. And in fact, there's lots of appellate law saying that that's an inadvisable way to do spousal support, is just say a strict calculation. The issue becomes is, was my client appropriate in retiring, number one, and then if not, if he was doing this for the purposes of defeating an obligation, then okay, let's impute that income. But I think that the council's position is stepping over the fact that he was 64 years old at the time of this hearing. And for the trial court's position to be saying, oh, that's early retirement, that's it, is then what is appropriate retirement under the trial court's analysis? Is it a case-by-case basis? Did they find that these factors, such as giving notice 28 months later, I mean, the court doesn't mention that at all. The other issues is that her income at the time of the trial was not just $1,000 a month. So her $1,000 a month was her employment, her active employment. Although she has this health issue, this brain tumor issue, she indicated that she is capable of working full-time. This job is essentially full-time, flat salary of $1,000 a month. She sees a doctor once a year, has an MRI every 2 years. There was no testimony within that record to establish that a health condition prevented her from working. So she has $1,000 a month from her efforts in working. On top of that, $65,000 a year on average from the family business, $6,000 a month in interest income, and then anywhere from $7,000 to $10,000 a month, or a year, both of those a year, as a financial advisor for which she could not account. She indicates it's on her tax return, she has no idea why, but she gets that income. So when you look at that as a whole, wife is making substantially more income than $1,000 a month compared to former husband who's making $200,000 a year. As far as him being economically sound, or his position that he was economically sound in reaching this retirement decision, he indicated he did not draw on his 401k because he didn't have to, and he was living off of his savings. Wife, again, this was a long-term marriage. Wife received an equal division of property years before under the terms of the divorce decree. So if husband's saying, I'm able to live off my savings, it is a logical argument that wife received about the same amount of at least the marital estate that husband did. And so when we're comparing not only income, but relative assets and liabilities, the record does not support that wife was significantly disadvantaged as far as her assets and liabilities go as compared to husband. The additional issue of this money from the family business. The record indicates that it's property that was certainly allocated to wife. It is void of any indication of how this income, if there was any income at the time of the divorce, was treated for spousal support. It doesn't say that any income she derives from that business is separate. It doesn't indicate that it won't be included. The record doesn't even say what she was making from that family business at the time of the
Also,
divorce.
I have to ask you to wrap up.
Yes, thank you, Your Honor. I will wrap up. Thank you for your time. All. Have a good day.
Thank you. Thank you both for your arguments. The court will take it under advisement and issue a decision in